Bienvenue à la réunion numéro 8 du comité mixte spécial sur la déclaration de situation de crise. No translation? Oh, okay.
Senator Carignan can hear, so everything is fine. Apologies. Do you hear the interpreter? It's working? So I'll start again. So I'd like to call this meeting to order. This is meeting number 8 of the Special Joint Committee on the Declaration of Emergency, pursuant to the House of Commons Order of March 2nd, 2022, and the Senate Order dated March 3rd, 2022. Today's meeting will be conducted in a hybrid format, pursuant to the House of Commons Order dated November 25th, 2021. For reasons of health and safety, I thank all people here in person for complying with health authority recommendations. For any technical issues, please advise, so we may, if required, suspend the meeting for a few moments so all members can fully take part in the meeting. This committee is meeting today to discuss future business. It will be up to the committee to decide on the motions it wishes to discuss. An updated version of the work plan was distributed to members of the committee. We have 3 meetings planned before the summer adjournment: Tuesday, June 7th, Tuesday, June 14th, and Tuesday, the 21st of June. We will have to decide on the witnesses that the clerks can invite to appear for these 3 meetings. I gather that tonight there will be some votes at the Senate. We will adjourn at that point or suspend, so our Senate members may leave at that point. You have the floor.
Déjà des tours de parole.
We already have orders of questioning.
Avant qu'on soit... Bon, OK. Alors... OK. Bon, OK. Alors, je constate que Mme Bendayen, M. Mott...
I noticed that Madame Bendayen, Mr. Motz, and Mr. Nakvi want to speak. Ms. Bendayen, you have the floor. Thank you, Mr. Chair. I understand that we have a lot of work to do and a number of motions before us that were circulated. Of course, we are eagerly awaiting this discussion on the production of documents. I personally have a motion with respect to our scheduled meetings and the availability of witnesses. We've already discussed, for instance, the Minister of Finance, the Minister for Public Safety, Minister Bill Blair, that is. Would you be fine with me putting that motion forward so we can go through this relatively quickly? These dates are coming up, and then perhaps we could move to the other motions at that point. I would ask that the committee discuss this motion, and then I'd ask the clerk to circulate it to all members, and I have copies here.
Alors, oui, pardon me? Oui. OK, ben je vous écoute.
You have the floor, Mr. Motz. Go ahead.
Chair, and just to Ms. Bendayen's motion, I would respectfully suggest that we deal with at least one of the motions that are before us today, and that's on documents, and then we work on a work plan after that. I don't think the documents motion is going to take long, and then we move forward with developing a work plan and witnesses and stuff that could take the majority of our session. I'd hate to be in the middle of a work plan discussion that could take us to the meeting and then not get to the documents motion. This documents motion's been before us for some time, and I would suggest we do that first and then certainly move forward with what's the work plan moving forward and who's going to be here and what dates and what does that look like. That's my suggestion.
Merci. Est-ce qu'il y a quelqu'un d'autre?
Thank you. Anyone else on this particular issue as to whether we want to start with the production of documents or the witness list?
Monsieur Brock?
Mr. Brock.
I concur with my colleague, Mr. Motz.
Diane?
Just to respond to,
Pardon me?
to Mr.
Well,
Motz, I totally agree. Obviously, we will be dealing with the production of documents motion that you put forward, colleague. I have moved this motion, so I'm not sure if you're suggesting that we adjourn debate on this particular motion. I would just signal that these are witnesses that we've already all agreed to, and this is just a matter of slotting them in over the few weeks that are left to this session. So I wouldn't anticipate that this would be subject to very much debate. These are the availabilities of ministers. We either take them or leave them. I certainly hope we will take them. And it's not a full work plan. It's a matter of the next few weeks.
Monsieur Green.
Mr. Green.
I wanted to indicate to the committee that the motion was duly put. It is live, and so for that reason, I think that I certainly support moving forward with getting that segment done, and I would anticipate that we'll have plenty of time to get to the production of documents. So,
Est-ce que je comprends?
Am I understanding correctly, Ms. Bendayan? You're saying that you agree to us working on the motions on the documents first, or no? No. Sorry, you wanted to discuss the motions on the issue of the motion on witnesses? Yes, I just wanted to say it's just a matter of a couple of minutes here because we already agreed as a committee that these witnesses must or should appear. It's just a matter of the dates. You said you had paper versions of it. Could you distribute that to everyone?
Ouais.
No, I haven't.
no.
I think it's. I just want to put this on the record as well. We put our witnesses together, witness list together some time ago, and I said I haven't seen the list here. We had a document come out from the analyst on a work plan moving forward, and then prior to the 13th of May, there was some more witnesses added, and interestingly enough, many of those witnesses who were Liberal witnesses ended up in the work plan without a conversation. And I just want, I find that interesting, and I just want that to be on the record.
Je comprends.
From what I gather, we already had in the work plan planned meetings 9, 10, and 11. We already had witness lists for those meetings. We had already indicated witnesses for these 3 meetings, the 9th, the 10th, and the 11th meeting. Did we agree to that? Ms. Bendayan, what you're suggesting is for the future meetings for those meetings? Or you have before you, Mr. Chair, the motion providing for witnesses for June 7th, that's next week, and June 14th, which is the following week, and the 21st. And it is due to the fact that we had to cancel our meeting 2 weeks ago because of the filibustering of other colleagues in other committees. So the dates had to be revised, and it has to do on our side with the availability of ministers, which is something that we've looked into. Again, Mr. Chairman, there are witnesses that these are witnesses we've already discussed as a committee. You have this list before you, and I would note that last time we wanted to speak about our work plan as a committee, we were told it just wasn't the right time and that had to be done during a committee business meeting. Okay, Mr. Virani. I just wanted to mention something that Mr. Motz just referred to.
Are appearing Liberal witnesses without a conversation, quote unquote. So perhaps I misheard him, but I'm just going to reiterate that people like the DOJ officials, Department of Public Safety officials, the Minister of Finance, the Minister of Emergency Preparedness, the PPS, the Black the Usher of the Black Rod, the Sergeant at Arms, the OPP, and the Auto Police Service were all extensively discussed over the last 4 weeks. And all we're dealing with now is when they should arrive, not whether they should arrive. So for that, so I just want that clarified. Secondly, this motion, as Mr. Green pointed out, is correctly on the floor. So we have to deal with this motion before we decide to whether or not to deal with the production motion. So, yeah. So I just wanted to put that out there. Merci, Monsieur Fortin.
Merci, Monsieur Virani.
Thank you, Mr. Vilta. Thank you, Mr. Virani. On the list, I have Ms. Bendayan, Mr. Motz, Mr. Naqvi, who've already spoken, Mr. Green, Mr. Brock, and Mr. White. So Mr. Brock and then Mr. White.
A couple of things, Mr. Chair. Thank you. There's another option that we can adjourn debate on Ms. Bendayan's motion so that we can get down to some of the other stuff that we had proposed to deal with at this particular point in time. And I also want to correct the record. Ms. Bendayan indicated that we'd lost this particular session 2 weeks ago due to filibustering at various committees. The chair was at a committee that I was at, that was Justice, 2 weeks ago, and the correct interpretation of what happened was that the Liberal committee members refused to adjourn the proceedings at 5:30. We had a 2-hour block as a result of their refusal to adjourn those proceedings, which was supported by the NDP. We continued the session, which ultimately prevented this particular committee from sitting. So I want that on the record clarified. Thank you.
Monsieur Brock. Monsieur White.
Thank you, Mr. Brock. Mr. White.
Thank you very much, Mr. Chair. A couple of things. If this list is what we've already discussed, and from looking at it, I believe it is, I am fine, but I will be bringing a motion on any new witnesses that we go in camera, because there will be discussion that I don't think should be made public about whether we should or should not call specific individuals as witnesses here, and the fact that maybe we'll be challenging or discussing their credentials and things like that. So I don't think there's a different list than what we have here now that we've discussed over the last 6 weeks probably, then I'm fine. There are issues with who represents Parliamentary Protective Services. The Usher of the Black Rod is actually not responsible for security in the Senate. Julie Lacroix, who's the departmental security, is, unlike the Sergeant at Arms in the House of Commons. So it's the wrong person. And I would make a suggestion that the list, number 3 group, that we finish the session with people who work on the Hill, because we're going to have bells and such, and have the OPP and OPS the week before. But as long as we're not adding anyone new, I'm okay with us dealing with these ones, but I would like to flip 3 and 4. Mostly because having people come from Aurelia with the Ontario Provincial Police to sit outside for 3 hours while the Senate probably deals with bells, we may not get to them, and it would be unfair, and probably important that we hear from them before we break for summer session. Thank you, Mr. Chair.
Fermez votre microphone.
Alors, là, ce que je comprends, c'est
Okay, from what I gather, there's no one else on the list. So Ms. Bendayan's motion should be voted on. Yes, Mr. Chair, I believe our colleague Senator White put forward an amendment. Just wanted to clarify that. You're right. You wanted to change 3 for 4?
We would be supportive of the amendment.
OK. Est-ce que ça, c'est. On a un consensus?
So is there unanimous consent to flip 3 and 4? Yes, okay. The other thing I'd like to draw to your attention is that in the event that one of those witnesses were not available, or if there were to be, us having to delay a meeting, etc., rather than have us be called here for uselessly in a way, that it would be good for us to change this list or amend the list so that we would have extra witnesses that could stand in for others who are not available. Would that work for you, Ms. Bendayan? Would that be okay? Yes. Mr. Brock?
I'm proposing another amendment with respect to clause number 4.
Est-ce qu'on pourrait juste compléter cette...
Can we just get to this, what I'm putting forward here? It's another amendment, sir?
Si vous dérange...
If you don't mind.
What you're proposing? I missed that. Could you repeat it, please?
Okay, just because you didn't click on your mic, so I don't hear you.
Oh, sorry.
Ouais. OK, alors, est-ce que vous êtes d'accord?
Do you agree to amend Ms. Bendayan's motion that was already amended by Mr. White? So we would flip 3 and 4, and we would add a provision that in so far as witnesses are available and in the event that it's required, that the 3 co-chairs can discuss matters with the clerks to add other witnesses. Is that okay unanimously? No vote on that? Does that work? Okay. We'll vote on it? Is that okay?
Pardon me?
The motion and the amendment.
OK, alors allez-y. monsieur.
First of all, I know 3 and 4 now have been flipped around, and I'm fine with that, but who from the Ottawa Police Service and who from the Ontario Provincial Police? That's pretty ambiguous. We need names, because I can't support an Ottawa Police Service. I can't support an OPP.
We have to have
Who
the
are they?
former and then
Who
the
are
new
they?
one.
I mean, we have lists of witnesses from both of those agencies that should be called, and you can't have a motion like this with that.
Say Commissioner in Chief, and if they send DC and DC, we're stuck with it.
Well, yeah, it's not my motion, but I can't support a motion where we don't know who's going to be here.
Are you proposing an amendment? You can easily specify who you would like in the motion.
Sure. I'd love to. So, hold on.
Commissioner Carrick and
And I would also suggest that once I give you the names, that our time allotment for that is certainly not enough. I know we're talking 1.5 hours for both individuals, as I read number 4 as it's written here, and that is not sufficient enough time for either one of those agencies, quite honestly. And if I look back over our discussions from previously, we talked about expanding, the Ottawa Police Service people who are going to be here. So that would be my suggestion. The Ottawa Police Service Deputy Chief Ferguson, as well as Interim Chief Steve Bell, can be added. It should be included as to the Ottawa Police Service list, and the OPP. They have the commissioner there. How do you say that? Carrick. And any senior officials that he might bring, and they should have an hour, 1.5 hours each.
we only have those 3 days, right? That's all we have.
Yeah, and so an hour and a half for each session.
Yeah. Yes,
And they can, certainly they need to be open to bring whatever officials from both agencies. Then the invitation should be open enough that they bring whatever officials that can speak to the invocation, like we talk about here in the act, or in the, that they could add some value to our meeting.
Si j'ai bien compris,
Okay, if I've understood you correctly, Mr. Motz, you're suggesting for the Ottawa Police Service, the current Chief of Police and the previous Chief of Police? Mrs. No?
Indicating Interim Chief Bell
OK.
and their Deputy Chief Ferguson for an hour and a half. And then I'm proposing the commissioner from the OPP, Karik and any senior officials there for an hour and a half.
Sorry, the Commissioner, Mr. Carrick, and then,
And senior officials, whoever.
oh, senior one, okay.
Cancel the parliamentary security. Because there's no other time, right?
They're listed above that, are they not?
No, but if we take the full 3 hours.
Oh, we take the full 3 hours. Yeah,
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 it won't be called the session.
yeah. So then 3 is pretty well gone.
Push it, yeah.
Yeah. So 3 would be removed at this point in time, and number 4 becomes 3.
Oh, my God, now we really.
So if that is being moved as an amendment, and if I'm reading the room correctly, I think that would be, certainly it would be acceptable to me. It would be unfortunate, of course, not to have the Parliamentary Protective Service, but we can schedule them for the next session. But just to be clear, so we would only be calling Bell and not Slolly. Is that correct?
I think Solly's on the list for another time alone
Okay.
by himself. Yeah. Yeah.
Si je résume,
Okay, so in essence, June 7th, we would have a Department of Justice official and another representative from the Department of Public Safety, an official, for an hour and a half each. Am I right? Is that correct? And then on June 14th, you'd have the Minister of Finance and Deputy Prime Minister, as well as the President of the Queen's Privy Council for an hour and a half each. So that would be rather June 7th and then June 14th. And then on the 21st, we'd have the Commissioner Carrick from the OPP with a senior official, as well as the interim chief, a police chief for Ottawa, Mr. Bell, and Mr. Furious, a deputy, or I think you said deputy chief of the Ottawa Police for an hour and a half each. Have I understood this correctly? Is there unanimous consent for that? Everyone agreed? Very well, thank you. All good? Ms. Burke?
oui. Monsieur Mott,
Mr. Motz?
intervenir.
We're done this one?
Oui, je pense que
Unanimous?
c'est.
I think so. Now we're moving to your motion.
Allez-y.
Go ahead.
Thank you very much. I just wanted to make sure because sometimes the translation does a good job, but my ears when I was pick it up and then my brain has to digest it. So I'm a little slower than normal on that uptake. I'd like to then let's move forward then, if I could, Chair, to move that we resume the documents motion conversation or discussion, and if possible, could I ask the clerk to read that motion again into the record, please, and then I'd have some comments after that.
Just in the interest of time, Mr. Motz, is that necessary? We've all got it.
Was it read into the record in an in-camera session? Was it read into the record on a
I
public session?
have no recollection, but
I don't either, and that's why it's important, I think, to have it read into the record publicly. Pardon me?
It'll be in the minutes.
I'm looking at, I think the importance of having it read into the record, not for our minute, but for those who will be joining us online so they know exactly what we're talking about.
Okey-dokey.
De toute façon, c'est une motion qui est assez.
This is a long motion. I think it might be worthwhile reading it again. Ms. Bendayan, if I recall, had an amendment to put forward on that motion, so it might be worthwhile to make things really clear so we know what we're talking about. Madam Clerk, will you read this?
Oui, Monsieur Brock?
Yes, Mr. Rock.
While the clerk is doing that, it would have been my request as well, because I am aware of Ms. Bendayan's sub-amendment, and that was discussed in camera, and I would be asking the clerk to read that into the record as well.
Oh, ça me va. Ah, Madame Burke, êtes-vous prête à nous lire ça?
Ms. Burke, are you ready to read that?
Monsieur le Président, ça faisait partie de discussions
Mr. Chair, that was part of discussions.
reflétées maintenant publiquement. Moi, je serais très à l'aise de présenter.
I'd be quite comfortable putting forward my amendments, but I think it would be up to me to do that. Yeah, that's fine by me. So let's read Mr. Mott's motion, and if Ms. Bendayan wishes to put forward an amendment, then we'll deal with that. Madam Burke.
But just to be crystal clear, Mr. Chair, so nothing that was discussed that was in camera, that remains in camera. All that she's reading is the text of the motion. Correct? Good. Thank you.
Motion is to resume debate on the motion of Mr. Mott's moved on March 24th, correct? That an order do issue for all security assessments and legal opinions which the government relied upon in determining that A, the threshold of threats to security of Canada as defined by Section 2 of the Canadian Security Intelligence Service Act required by Section 16 of the Emergencies Act had been met. B, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not, open quote, be effectively dealt with under any other law of Canada, closed quote, as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that F, these documents shall be deposited with the Law Clerk and Parliamentary Council of the Senate, the Law Clerk and Parliamentary Council of the House of Commons, and any legal counsel which the committee may appoint in both official languages within 1 month of the adoption of this order. G, a copy of the documents shall also be deposited with the law clerks and any legal counsel which the committee may appoint in both official languages within 1 month of the adoption of this order, with any proposed redaction of information which, in the government's opinion, could reasonably be expected to compromise national security or to reveal details of an ongoing criminal investigation other than the existence of an investigation. H, the law clerks and any legal counsel which may be appointed by the committee shall promptly thereafter notify the co-chairs whether they are satisfied the requested documents were produced as ordered, and if not, the co-chairs shall be instructed to present forthwith, on behalf of the committee, a report to each House outlining the material facts of the situation. I, the co-chairs shall cause the documents as redacted pursuant to paragraph G to be distributed to the members of the committee and to be published on the committee's website forthwith upon receipt. J, the law clerks and any legal counsel which the committee may appoint shall discuss with the committee at an in-camera meeting to be held within 2 weeks of the documents being distributed pursuant to paragraph I, whether they agree with the redactions proposed by the government pursuant to paragraph G, provided that, upon the request of the government when depositing the documents, the co-chairs shall be instructed to present as soon as possible on behalf of the committee a report to each House recommending that this meeting or any subsequent meeting where the discussion is continued, 1, shall, notwithstanding the order of the Senate adopted on March 3rd, 2022, not be subject to the provisions of paragraphs A to C in the order of the Senate adopted on February 10th, 2022, respecting senators on standing joint committees. 2, shall, notwithstanding the order of the House of Commons adopted on March the 2nd, 2022, not be subject to the provisions of paragraph R of the Order of the House of Commons adopted on November 25th, 2021. And 3, may, if the committee decides, be held outside of either House's precincts, but within the National Capital Region at a location acknowledged by the government to be appropriate for the discussion and presentation of highly classified information. And K, the committee may, after hearing from the law clerks and any legal counsel, which the committee may appoint pursuant to paragraph J, accept the proposed redactions or reject some or all of the proposed redactions and request the production of those unredacted documents in the manner to be determined by the committee. French too?
Merci, Madame, Madame Burke.
Thank you, Madam Burke. That's your motion, Mr. Botts?
And I appreciate.
Je vais vous laisser la parole.
I'll give you the floor on your motion, but I noticed that Mr. White would like to speak as well. If anyone else would like to speak, raise your hand, and I'll add you to the list.
Thank you, Madam Clerk, for reading that out. I appreciate it. I think what's important here is what's become clear through the process over the last since the 23rd of February, and since we've had witnesses here already and comments that have been made publicly, that the government has chosen to maybe withhold, hide behind cabinet confidences or lawyer-client privileges. So there's no clarity at this stage of any of our witnesses, and I don't anticipate the government being forthcoming with any clarity that would allow us to who asked for the Emergencies Act, what the information that they were dealing with that precipitated them asking for it, and anything the government used to rely on to invoke the Emergencies Act. And we believe, I believe, that the documents that we're asking for in this case, are the information are contained within those documents for us to make an informed decision. And the act, we've all said around this committee, the Prime Minister has said that Canadians deserve transparency and accountability on this matter, and I think it's prudent that that's the move we go. I can go into more detail, but I'll just leave it at that. I think the motion kind of speaks for itself. Thank you.
Merci, Monsieur Motz. Monsieur.
Thank you, Mr. Motz. Mr. White.
I'd like to bring forward an amendment, removing everything from J on to the end, and leaving the rest as is. You can bring another amendment afterwards. Okay. It's just mine. Otherwise, it makes it convoluted.
Can I ask a question of clarification on that then, Chair? So, Senator, if you remove J, from J onward, can you explain how you then anticipate the navigation of these documents once they're received by this committee to take place?
Well, I think, thank you very much, Mr. Chair. I think once we remove that, we can actually then bring forward an amendment identifying how the documents are brought to us. But trying to fix this and removing redaction pieces, it's much easier to remove it all and then put in one section stating that all documents will be delivered within 30 days, that type of thing, rather than trying to deal with, because there's too many pieces to this puzzle.
If I can, Chair, well, I'm still, okay, I think I understand what you're getting at, Senator. I think. So if Jay actually talks about the law clerks and the legal counsel, would hold the documents, the unredacted documents as well. And they would compare them with the redacted documents.
That's what I'm saying. They can't do that.
Okay,
So I'm arguing they should not do that, and that's what my amendment is.
Who should then?
No, nobody should compare the redacted documents with unredacted documents.
Okay, so you're saying that the redacted documents we get, even we might get 150, 200, 500 pages of all black.
And we could, and we have pathways then, but right now we're presupposing what we're going to get, and we don't know what's going to come. And look, if I may, Glenn, you and I know what we saw. we would lose three words in 4 sentences, right? We could always tell what was in those, presuppose we would know what was in those redacted documents at NSTCOP. But I think we're presupposing now that we're not going to get anything. I think we have to make a decision on what redactions we have when we get them. And then we have pathways, but we don't have a pathway now. And I think asking a law clerk to look at cabinet confidence, to look at client lawyer, solicitor client privilege, and make a determination of what's right and wrong, they don't know, to be fair, and they shouldn't have access in many cases, nor should they have access. So my perspective is, I'm not suggesting we'll be happy with the redactions. I'm suggesting we won't know until we get those redactions. And then we can make decisions. I think we shouldn't make them now, that's all. Thank you for lenience, Mr. Chair.
Merci, Monsieur White. Merci.
Thank you, Mr. White, Mr. Motz, for that clarification. I had Mr. Virani on the list and then Mr. Green. Mr. Virani, you have the floor.
Thank you, Mr. Fortin, and thank you, Mr. White, Senator White, for that suggestion. In terms of sort of what I was going to address is that, well, first of all, on a couple of points, just to make sure that the record is clear, I think Mr. Motz had said in his comments that the government was, quote, hiding behind cabinet confidence and lawyer-client privilege. I think cabinet confidence is a very entrenched notion in the Westminster style of government. It is to ensure candid cabinet conversations can take place for the betterment and the public interest of all people that reside in this country. I think it's quite sacrosanct in our tradition. It predates the Charter, and it is an important thing to uphold. So it's not an issue of hiding behind something. It's actually an issue of maintaining a principle that allows government to continue. Lawyer-client privilege is equally sacrosanct, and I'll declare my subjectivity on the matter clearly out in the open. There are many other lawyers around this table, but the reason why you have lawyer-client privilege is that so a client can feel confident in having open and very blunt and candid canvassing of all various options with their counsel. Without that kind of secrecy to the communications, you don't have the provision of legal advice that is in the client's best interest, and that is in everyone's best interest in this country. So I just reject the assertion that people are hiding behind these principles. We are trying to uphold them because they're important for our democracy. That being said, I agree with much of what Senator White has suggested with respect to a surgical amendment to Mr. Motz's motion. I would actually take it a little bit further to indicate further to his point about the documents not being potentially evaluated or compared or contrasted by law clerks or any other legal counsel. So I would say, apropos of omitting everything from J onwards, I would actually say that the original H, which reads the law clerks and any legal counsel which may be appointed by the committee, should also be struck. And what I would further indicate is that reference to the law clerk and parliamentary counsel and law clerk and parliamentary counsel of the Senate or the House of Commons in paragraph F should also be struck. Yeah, and just to finish off, closing off the list is that I do think in paragraphs D and E, reference to specific legal advice that was provided to the Minister of Justice in respect of his responsibilities under the Department of Justice Act. I think to any lawyer reading those phrases, and again, there are many lawyers around this table, that clearly is legal advice that's being provided to the minister and would fall under what we call solicitor-client privilege. So I don't think it's appropriate to be included here. So I would suggest that we omit that reference, the words including to the end in paragraph D, and the words including to the end in paragraph E. And I'll pause there. Thank you.
Merci.
Thank you. I'd like to suspend for just 1 minute. I just wanted to say I have Mr. Green and Mr. White. I'll be suspending for just a few seconds.
To come and allow this one just to move forward.
Merci. Alors, Monsieur White.
Thank you, Mr. White.
Deal with the chop and slice, but I think we need to deal with one amendment, if I may. Thank you.
Actually, sorry, I do have one
Oh,
point
no,
on
too
this
late.
amendment. I do have one point on this amendment. Yeah, my concern is that when it comes to demand for documents, if there isn't a clear date put forward, then the government's refusal, delay, or refusal by delay to provide them, unless there's an actual
We can add that afterwards.
a date on it.
We'll add that after we get rid of this. We'll add
Okay, when we go back to the main?
Guaranteed.
Got it. Okay, thank you.
Est-ce que quelqu'un d'autre veut intervenir?
Anyone else? Mr. Motz? On the proposed amendment for Mr. White.
Actually, just would like to make a comment that, I would accept Mr. White's, Senator White's amendment as a friendly amendment on the condition that we have a date inserted on that amendment that would say documents by a certain date.
I think we
Yeah.
could bring an amendment right afterwards,
As
putting in a
another
date,
amendment?
putting in a date.
Okay, okay,
Just-
well, we
but
don't lose sight of that.
Let's get rid of all this and then we move forward on the pieces. Is that okay? Okay.
Alors, on est prêt à voter sur l'amendement.
Are we prepared to vote on Senator White's amendment?
Oh, just the amendment.
Ça va?
Wait, ça va.
OK, tout le monde, ça va? Bon.
All good for everyone? Okay. On Senator White's amendment, withdrawing from Mr. Motz's motion, sections G and onward. Should I move to the vote, or is this unanimous? Let's vote.
J en français, J en anglais. Ouais. I know, Mr. Moss, I always make the same mistake. I understand. Mais J is J in English, but in French it's J. So since yeah. OK. Alors, Madame Burke, vous pouvez procéder à l'appel pour le vote, s'il vous plaît?
Est-ce que... Passe au vote?
Oui.
Yeah. All right. Do you want to go ahead?
Yeah.
Okay.
Est-ce que c'est unanime? Je pense que c'est unanime.
Yeah.
Is it unanimous?
Is it? Monsieur Moss, you didn't ask for the vote? No? OK. Alors, c'est unanime?
All right, so it's unanimous.
Oui, l'amendement de M. White est donc accepté à l'unanimité.
Unanimously. And now?
Ça va?
All good. And then now, let's move to the proposed amendments. Amendments moved by Mr. Varani. One at a time, please. Yes, one at a time. So two of them really...
Exact same sentiment, so I'll start with that because it's perhaps the easiest. So in paragraphs D and E, there is effectively the exact same language. And what I'm proposing is that we strike the language in paragraph D that reads, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And in paragraph E, I'm suggesting striking the exact same language where it says, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And the basis for that is that that kind of analysis is part of the legal advice that would have been provided to the Minister of Justice, and as such would fall under the well-entrenched principle of solicitor-client privilege.
Madame Burke. Ah, oui, OK. Oui, donc, Monsieur White, oui.
Mr. White and then Mr. Green.
Thank you very much, Mr. Chair. I respectfully disagree.
Why?
Having worked at public safety, I can tell you that the vast majority of the analysis we provided was not solicitor-client privilege. In fact, would not have come from a lawyer. I don't believe we should make the determination whether it's solicitor-client privilege. That's for somebody else to make.
Green.
Mr. Green.
Thank you, Mr. Chair. I've been sitting on this for quite some time, and we've heard in the opening remarks of Mr. Nakvi this notion, as stated as fact, that this idea of Crown privilege in cabinet confidence is sacrosanct and supersedes the will of Parliament And I think the references were into his experience as a lawyer, but I would like to put before this committee, and I'm going to ask for your graces in doing this, a compelling argument to the contrary. And I reference the powers to summon persons, papers, and records has been delegated to standing committees by the Canadian House of Commons under Standing Order 108.1 and by the Senate under Rule 91. Diane Davidson, General Legal Counsel for the House of Commons, has stated, the extensive powers that a parliamentary committee enjoys are not commonly understood and therefore, at times, not properly respected. That this may be due in part to an understatement. Consider for a moment the powers of standing committees as set out in Rule 91 of the Senate Rules and Standing Order 108.1 of the House of Commons. These include the innocuously stated authority to send for persons, papers, and records. No distinctions are made between the different types of documents or categories of witnesses. The very simplicity of the words granted by this authority would appear to belie the strength of the power thereby delegated. And when coupled with the rights of a committee as enjoyed as a constituent part of Parliament, these are very powerful indeed. I want to go a little bit further and reference another important point, which is, again, on Crown privilege, that claims of Crown privilege do not diminish or derogate from the power of the House to require attendance, testimony, or the production of documents. Diane Davidson, again, General Legal Counsel for the House of Commons, has stated that it is important to state that there exists no blanket immunity for the executive branch in making public interest claim against the disclosure of confidential information to a parliamentary committee. The so-called Crown privilege, or more modern designation, public interest immunity, is often invoked by the Crown and more often by ministers in refusing to divulge matters or to produce certain documents in a lawsuit on the grounds that it would be contrary to the public interest to do so. It should be noted that this immunity, and I put emphasis on this next point, has never been formally acknowledged by the House of Commons as inhibiting its investigatory powers. The public interest to be considered and weighed in judicial proceedings are not the same as the public interest to be considered and weighed when evidence is sought by parliamentary purposes. In practice, parliamentary committees have a more readily given consideration to claims of Crown privilege when invoked by a minister in relations to national security and international affairs. However, in the final analysis, the committee remains the final arbiter of such claims. Again, Diane Davidson, General Legal Counsel for the House of Commons. This is a convention. This has not in any way been something that has been given up by the House of Commons as a power. And I think that by framing this in the way in which it has been framed in the opening comments of Mr. Virani, it in fact undermines our power as the Grand Inquisitor of the nation. And we see this time and time again. And it's, you know, there are multiple lists. I heard that he framed it as it being one of the foundational principles of the Westminster system. If he would wish to continue down that road, I have examples from many other jurisdictions where this has been defeated in its very notion from every Westminster system. And I'm happy to state that should he have questions on those matters. But, you know, I'm not clear there's going to be a committee in my time on Parliament that's more important than the one that's before us. And if we don't get to the hearts of the matter in an open, public, and transparent way, one that doesn't at every corner seek to reduce, redact, and retract public inquiry into this, we're going to be back in this committee in no time flat, because that's where we are. And I've stated that time and time again, Mr. Chair, that regardless of what side of the issue Canadians are on, we have a duty as a committee to bring forth the truth and the facts of the matter. The challenge that we have, and I think the imbalance that this committee has, despite I think its very wise constitution of senators and party members, is that only one side has access to the facts. As somebody who supported it, I want to be able to go back to my constituents with the facts of the matter as presented in an evidence-based way that support the decision I made. I'm also prepared, Mr. Chair, that if the facts bear out that a mistake was made, then I think our responsibility as a committee is to provide recommendations back to the House of Commons and the Senate and Parliament that will ensure this doesn't happen again. So, you know, I don't want to allow the conversation around the table to continue to mislead Canadians on the power of this committee, or perhaps underestimate it or understate it in a way that isn't actually true to the jurisprudence of the House of Commons. Thank you.
Merci, Monsieur Green.
Thank you, Mr. Green. On my list, I have Mr. Motz, and I added my name because although I am a chair, the chair, I would like to speak. I see Mr. Virani also would like to speak to this point. That being said, I am seeing some lights. I think there's a vote, correct? Oh, House adjournment. We were expecting votes at the Senate. Will we have flashing lights for the Senate? No. Okay, you'll let us know. Okay, Mr. Motz.
Thank you. I appreciate the evidence that was brought forward by Mr. Green. I think that it's exactly the point of doing this, and I think we've all given this thought on what's our role here in this committee. You remove the partisan hats, and what is our role? Our role is to get and answer the questions that Canadians deserve to know about transparency and accountability, and that's all we want. We just want the facts. We want the truth to come out and not be hidden, because it behooves us as a committee to gather that. And I've always wondered why there is precedent. Like Mr. Green called it convention, that allows the belief that the executive branch can withhold whatever information they deem necessary from itself, from Parliament, from committee of Parliament, and who represent the Canadians. So I appreciate that. I think I certainly don't support Mr. Virani's removal of D and E. If those who redact those documents, Arif, let them make that decision. Let's not make it for them. We need to ask for full, frank disclosure and accountability of whatever information is there on everything that the government relied upon to make their decision on invoking this act. On everything, every possible angle the government looked at needs to be reviewed and redacted as necessary, given the parameters that redactions occur at. And as Mr. White said before, then we make the decision. Did we get enough information? Do we have enough to make an informed decision on moving forward? And I think that would be reasonable. And the whole idea is to ask for the information and see what we get.
Merci, Monsieur.
Thank you, Mr. Motz. Mr. Fortin will have the floor. I understand Mr. Virani's concern. That said, I subscribe to what Mr. Green and Mr. Motz have said 100%. I think we're here to shed light on a situation. And we can't already, before we have an objection about the production of a document or information, say, oh, by the way, we're going to self-censure in a way. It doesn't really make sense. But when I read Mr. Motz's motion, here we're talking about an order to have a number of legal advice and legal opinion and security assessments. And if I look at D, the emergency measures regulations comply with the Canadian Charter of Rights and Freedoms, including the analysis relied upon, etc. The analysis is not necessarily legal opinion. There was an analysis that was done, or might have been done, or should have been. That's what the motion is requiring. So if the minister who receives this motion says, I can give you the analysis, but I won't provide the legal opinion that it is based on, or that I'm basing this on, because of a solicitor-client privilege issue, then you could say, do we agree or disagree? But at this point, it's as though we're saying, Minister, send us the assessments and legal opinions, security assessments, that you used to do this analysis under 4.1. That, to me, strikes me as a minimal standard in terms of our work. That's what I wanted to say. But that said, Mr. Virani, you have the floor.
Monsieur Fortin,
Thank you, Mr. Fortin, Mr. Motz, Mr. Green.
to clarify one component is that the aspects of what's included in paragraphs D and E refer to Section 4.1 of the Department of Justice Act. And 4.1 of the Department of Justice Act is the requirement that is on the Minister of Justice to ensure that bills, statutes, regulations, etc., that are being enacted by the government are charter compliant. So from my perspective, and I believe this is shared by other members of this committee, that when you're looking at charter compliance, you are looking at, I know the word analysis is used in the text of what Mr. Motz has drafted, but when you're dealing with charter compliance, it is of necessity going to be looking at legal advice as to whether something is onside or offside of the charter, thus triggering concerns about solicitor-client privilege. And I just wanted to make it crystal clear that what we're talking about here is only solicitor-client privilege. Previously, in a different intervention, I mentioned things like cabinet confidence, but this is not about cabinet confidence, and it's certainly not about the notion of crown privilege, which is a more generalized notion. So I just wanted to put that out there. Thank you.
Monsieur Harder.
Mr. Harder and then Mr. Green.
I don't think we should prejudge what is sent to us. We should ask for documents in the fullness of the motion. And I don't want to prejudge the issues around cabinet confidence and solicitor-client privilege. I probably would side with a generous interpretation of that, but we'll come to that discussion. Let's ask now, and I know that there are analyses and advice given, even on charter compliance, that the government has put forward on bills and may choose to put forward. I hope they would. But we'll judge that when we get and see what we get. Let's not fight that fight prematurely. Yeah. We'll come to it. We may have a difference of views, but we'll then have that discussion and have a vote. So let's vote on it to get the broadest documentation possible.
Merci, Monsieur.
Thank you, Mr. Harder. Mr. Green.
I'm going to say something that might not always go on the record, but I will concede to the infinite wisdom of the Senate on this one, and we'll fight that fight. We'll fight that one. We'll fight that fight when we get there, I suppose.
Merci, Monsieur Green.
Thank you, Mr. Green. All done on this question? Are we prepared to move to the vote on the amendment? Are we ready to move to the vote on Mr. Virani's amendment to the effect that he was asking to remove from sections D and E, those sections that including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. So those words would be struck from D and E of Mr. Motz's motion. Is that unanimous, or should we vote? Vote? Ms. Burke.
Monsieur Fortin, après d'avoir entendu les...
After hearing my colleagues' concerns,
and I've heard enough that people understand the notion of solicitor-client privilege, and they appreciate that redactions are likely inevitable in this context. They just don't want to presuppose it. So I think my point has been made. So what I'm proposing to do is withdraw my suggested amendments to paragraph D and E.
D'accord, merci, Monsieur.
Very well, thank you, Mr. Virani. Yes, we'll get to that in a moment. Given that the proposed amendment was already on the floor, to remove it, to withdraw it, we need unanimous consent. Does everyone agree to that Mr. Virani withdraw his proposed amendment? Mr. White, do you agree? I see your hand is up.
C'est retiré, Monsieur Virani, merci.
Very well, then it's done. Now let's move to the next amendment. Mr. Virani.
Excusez-moi pour la...
I'm sorry for this grocery list, as they say.
So, Monsieur Fortin, Monsieur le Président, the next amendments I would group, there are three, and they relate to this notion of documents being deposited. And it is my position that the documents should be deposited with the committee, as opposed to references that refer to the law clerk and parliamentary counsel of the Senate and law clerk and parliamentary counsel of the House and any other legal counsel which may be appointed. So this language is tracked within 3 different sections. So my proposal, and I think we can deal with this all.
Juste un instant, Monsieur Viret. Est-ce que c'est un
One moment. Is this a point of order, Mr. White? Did you want it?
Mr. Chair, just for clarity, why wouldn't we start with A and look if there's any amendments, and if not, move to B, rather than, because what's going to happen, I'm afraid, is that we'll spend 3 hours bouncing back and forth, chopping up, if we can get agreement, I think we get through this in the next hour.
Tout le monde est d'accord qu'on procède?
We all agree that we start subsection by subsection?
Grocery list, but that's fine. He's got a more organized list. That's perfectly fine, Senator White.
Wait for dinner and I'm not having it.
Perfectly fine. We can start with A. Absolument. Merci.
The grocery list, you pay for the grocery, eh?
Ils sont très chers maintenant.
Very expensive these days.
Yeah, just on this point, is there really a need to go back to A? We're already down to F. Everything else
I don't know where we start.
between A and F.
I just
we're
don't want to
already there.
bounce, that's all.
He's got a grocery list.
Let's go,
Oh,
Tim.
So let's go to A.
Yeah.
See if he's okay with
Yeah,
that.
and move, that's all.
Yeah.
OK, alors on va procéder comme...
Okay, let's proceed in that manner then. Subsection A, Mr. Motz's motion. Any proposed amendments? Or is there agreement? Okay, that is passed. Section B. Okay, passed. Paragraph C. That is also adopted. D of the same motion is passed as well. E. Adopted. So paragraph F, Mr. Mott's motion. And now Mr. Varani has his comment. But here we are, where is exactly where I'd started, but that's okay.
And I'll do it. I just didn't want to necessarily repeat myself, but the basic notion with respect to paragraph F alone is that here it's talking about the documents being deposited, and it speaks to which entities. There's a reference to the law clerk and parliamentary counsel of the Senate, and the law clerk and the parliamentary counsel of the House, and any legal counsel which the committee may appoint. It is my proposition that we strike that language that I just read out and replace it with the word shall be deposited with the committee. And it would then continue on the second last line in both official languages within 1 month of the adoption of this order. So the words law clerk and parliamentary counsel of the Senate, comma, the law clerk and parliamentary counsel of the House of Commons, and any legal counsel which the committee may appoint are all struck. That is the proposition.
Merci, Monsieur Virani.
Thank you, Mr. Varani. Any debate on this, or is everyone in agreement?
Monsieur,
It's so clear that it'll be 1 month from the adoption today. Should it be adopted? Thank you.
ouais, mais le délai d'un mois, là, il n'est pas indiqué.
But I don't see that at paragraph F. And Mr. Varani's proposal is to strike those words. The law clerk and parliamentary counsel of the Senate, the law clerk and the parliamentary counsel of the House of Commons, and any legal counsel which the committee may appoint. Striking those, replacing them by at the committee, or with the committee. All in agreement?
Oh, est-ce que vous êtes d'accord, Monsieur Virani?
Do you agree with that, Mr. Varani?
Non, non, mais... Non, ça ne le dit pas.
Oui.
Ah oui, oui, dans le mois suivant. Oh, yeah. OK. Oui, oui, on garde la fin, Monsieur Green.
Yes, the end of that paragraph stays in both official languages within 1 month of the adoption of this order. Sorry, I had misunderstood. Everyone in agreement? Okay.
Monsieur Virani.
Mr. Varani.
I would actually propose to jump G and go to H because it's basically the same amendment. And I think it's very clinical and can probably be done.
Est-ce que si vous voulez sauter G, on va le voter.
If you want to skip G, we'll have to vote on that.
On a déjà décidé qu'on allait...
J comme Georges.
Oui.
Okay, J comme Georges. So here, again, the first, so there's a few amendments here. Je m'excuse, Monsieur Fortin, but
My apologies, Mr. Fortin.
part of the amendment would be to strike the language that again deals with documents being provided to law clerks and any legal counsel. So the first 4 lines in their entirety on my copy. So the words, "A copy of the documents shall also be deposited with the law clerks and any legal counsel, which the committee may appoint, comma, in both official languages, comma, within 1 month of the adoption of this order, comma, with any proposed redaction of," striking all of that. Okay. Yes, it follows logically from what I just recommended. And in the remaining portions, and I apologize if this is getting complicated, but I can provide you with a copy. So it would be to insert the words, so it now says information which in the public services, not the government's opinion, in the public services opinion, comma, could reasonably be expected to compromise national security, and then I would propose inserting.
Monsieur Grenier, l'avez-vous, la motion écrite?
Oui.
Do you have the written motion? I think we should take 2 minutes to circulate that. We might not be voting on the same text if not.
Mr. Chair, might I propose we take a...
Five-minute. Suspend, rather.
Allez,
Apologies.
adjourn. Monsieur Hart.
We will resume. Mr. Harder.
Merci, Monsieur President. I propose that we rule out paragraph G and H in their entirety, and then we vote on the main motion residing.
Là, on a un problème de fonctionnement.
This poses a problem because now we are working on Mr. Varani's motion. Wait a second. How could this be considered a sub-amendment? But right now we're on G. Okay, well, what you're proposing, Mr. Harder, is a sub-amendment to the effect that you would actually strike paragraphs G. Correct? Is that good with everyone? Everyone good with that? May I? Yes, go ahead.
My understanding, having spoken with Senator Harder during the recess, is that his desires, as he expressed, which is to remove all of paragraph G, all of paragraph H, and I believe all of paragraph I, because I refers back to G. So if G doesn't exist, you'd have to get rid of I. And I would say that I've consulted with Ms. Bendayan and Mr. Naqvi, and we're comfortable with that. But I would just want to note for the record that I've also taken observation of the fact that at different points, members, I think, of every party and of each chamber have indicated the understanding that it is not only likely but probable that redactions would occur in terms of the information that is being turned over. And I wanted to put onto the record that those redactions might take various forms, such as national security, as Mr. Motz's motion originally disclosed, the existence of an ongoing criminal investigation. They may also include, and I would want the record to reflect this, things like solicitor-client privilege, cabinet confidence, or matters that are currently before the courts, as there is already litigation that is ongoing on a constitutional basis about the very subject matter with which we are speaking. So having said that, I would reiterate that I believe myself, Ms. Bendayan, and Mr. Naqvi are in favor of removing paragraphs G, H, and I in their entirety. Thank you.
Merci, Monsieur Virani.
Thank you, Mr. Rani. Mr. Green.
Well, I appreciate Mr. Varani's positioning for his caucus. I certainly do not accept that as the rationale for why I am supporting this particular thing. I come into this with no presuppositions about what we're going to receive. That's the spirit of why I'm supporting this, and that doesn't in any way confer that I am, condoning nor accepting that we're going to receive a bunch of redacted documents. And I am putting that on the record.
Monsieur Motz.
Mr. Motz.
Thank you, Mr. Chair, and thank you both, Mr. Varani and Mr. Green. I would tend to agree with Mr. Green. I support the idea. This committee needs the documents. I do not want to presuppose that, as Mr. Varani is suggesting, that Canadians, this committee should expect to have fully redacted documents, solicitor-client privilege, cabinet confidence, national security issues, all those things, and because of that, we're setting up the platform to get nothing. And if we get nothing, we're not done. I'm putting that on notice that we're not done. So that's on the record too. Yeah, we're not done. That does not mean that that's what Canadians are going to get. And so I think that's important to appreciate that Canadians have expectations, and we're here to serve them.
Merci, Monsieur.
Thank you, Mr. Motz. So, on paragraph G, Mr. Varani's motion is that he's actually withdrawing it. He's suggesting that we do away with G, H, and I of Mr. Motz's motion. Everyone in agreement? Am I understanding correctly? So is everyone in agreement? Ms. Bendayan. It might not be fully relevant, but I think the amendment was put forward by Mr. Harder and not Mr. Varani. You're correct? My apologies. Actually, it wasn't moved, but I understand. Okay. Mr. Motz.
Sorry, I apologize, Chair. I think one of the things that we cannot remove is to some degree, that be published to the committee's website forthwith upon receipt. That was in the motion, and I think that needs to stay, as is indicated on, it would be the new H, or however that is, on Mr. Varani's, the co-chair's cause of documents as redacted pursuant to paragraph F, it would be now, where there is no G, be distributed to the members and be published in the committee's website forthwith upon receipt. That needs to stay.
Monsieur Mott,
Mr. Mott, I see Mr. Harder and Mr. White who want to speak, but I think that there is a mistake or a misunderstanding. We've already amended paragraph F to say that the documents will be produced to the committee. So it won't be the chairs, it will be the committee. So, Mr. Motz,
comprenez-vous?
do you understand?
What we should do is add to F the end of that, what was previously I, be distributed to the members of the committee, which we have in F now.
It's already there.
But what isn't there is and be published to the committee's website forthwith upon receipt. That is not in F, and it needs to be in F.
OK, je comprends.
That's
Donc,
what I'm. That's,
Okay, I get it. So at F, I see your names, Mr. Harder and Mr. White. I'm aware. Mr. Motz, I just want to understand that what you're putting forward here is that we keep what we had under I, or the end of I, that says published on the committee's website forthwith upon receipt. You would like that to be added to F after we see here that it be produced in both official languages, correct?
sorry. Yes, Chair. The F could then read as proposed. These documents shall be deposited with the committee in both official languages within 1 month of the adoption of this order, and then we could just add that the end of it and be published on the committee's website forthwith upon receipt.
OK. Je sais qu'on...
Okay, I know we're straying from ordinary rules of procedure. Just to be clear, though, it might be useful to say, is everyone in agreement with what Mr. Motz is? No? Okay, Mr. Motz, thank you, but we will keep to what we were working on, which is Mr. Harder's proposal to strike G, H, and I.
What?
Let's vote on it. Vern, you agreed to it earlier. No, I don't agree with putting it on the website. Like, we decide on it when we receive the
Let's
document.
receive it and then decide.
Then we decide. We're our own committee. But your earliest intervention. But who
Basically omitted everything beyond paragraph I.
No, that was just to clean up that piece of, and then I said we would deal with the rest, paragraph by paragraph. But if I may, Mr. Chair, from my perspective, look, we may end up putting it all on a website, but I'd like to actually see what we receive rather than be obligated to throw it on a website through a motion. My perspective is that we deal with, when we receive the documents, we'll make adult decisions as a committee, then we may put everything on a website. And the truth is, as a committee, we'll have the documents. Nothing stops any member from doing what they want with them either.
Merci, Monsieur White.
Thank you, Mr. White. Yes, I see. No. Everyone, listen, things are going to get confusing here. So we have Mr. White, Mr. Harder, and Mr. Green, Mr. Varani on a list. So I just remind everyone that we're going to address each amendment one at a time, or we're going to get confused. We were at paragraphs G, H, and I that Mr. Harder is suggesting we strike. So I will be hearing about that particular motion. Mr. White, are you done with what you had to say, or did you have anything else?
OK. Alors, Monsieur Harder,
Okay, Mr. Harder.
c'est beau. Monsieur Green.
I do want to just state that one of the challenges I'm having with this committee is the notion that we were struck in a special way, sworn in, which first time I'd been sworn in a committee like that, which I assumed would have granted us a deeper access into documents. What I am concerned about, so first of all, I am a proponent of open and transparent government. And I am unclear that what we're going to, I guess I don't know what we're going to get, but my concern is that this committee is in many ways being relegated to the same threshold of openness and transparency as the public. And we have hopefully a much higher mandate than that. And so I'll just state on the record now that, I am supporting the way in which we've modified this motion in good faith, that we will get substantive information. I'll even state on the record that should information contained within the documents as submitted to this committee require us going in camera for review, then that's something we should expect to do. But if what we end up getting is things that would generally be available to the general public, then I would state for the purpose of the record that that would be a great disservice to this committee, that would in fact undermine, I think, the principles through which the House and the Senate sent us here and create a whole other subset of problems down the line.
Merci, Monsieur Green.
Thank you, Mr. Green. Anyone else on the motion to strike these? Mr. Franny? Yes, I'll be very brief.
Agree wholeheartedly with what Senator White has said, and I think it's consistent with earlier interventions at different points in this committee's deliberations tonight about not presupposing. So the same way we have agreed by consensus not to presuppose the bases of redactions or assertions of privilege, I think presupposing what should or should not appear eventually on the website is probably a premature to determine at this stage, which is why, to my mind, I think it makes sense to go back to Senator Harder's original suggestion rather than reference now what goes or doesn't go on the website, just to strike subparagraph I in its entirety, along with striking G and H. Merci.
Est-ce que ça va?
Is that good? Everyone in agreement? Or do we vote? All in agreement? Okay. So G, H, and I have been struck from Mr. Motz's motion. I think here we are where we are to decide on the motion. We have already decided to strike J and following, and now J and following, or G and following. A, B, C, D, and E remain. F has been amended. So we have the committee instead of the law clerk, etc. So now Mr. Motz's motion as amended. Do we want to vote on that, or is it unanimous? Unanimous? Okay, so Mr. Motz's motion is adopted as amended.
Est-ce que d'autres motions?
Any further motions?
Chair.
Oh, oui, Monsieur Naqvi.
Yes, Mr. Naqvi. I didn't see you. I've forgotten you, basically.
You've forgotten me for last hour, so I've had my hand up a few times, but that's okay. I understand. I would like to move a motion at this time as well.
Allez-y.
Go ahead, Mr. Naqvi.
Thank you very much, and I'll read the motion, and I believe the staff will be circulating the motion. And the motion, Chair, reads as follows: that the committee instruct the analysts to prepare an interim report, and that this report be tabled in the House no later than Thursday, September 29, 2022, and that the committee instruct the analysts to prepare a final report, and that this final report be tabled in the House no later than December 8, 2022.
Mais est-ce qu'on peut...
But May 31st, can we decide on an interim report? You would like that in September, if I understood that correctly?
I'm suggesting interim report by September 29, 2022.
Okay.
And a final report no later than December 8, 2022. I believe the clerk should be getting the motion in English and French.
Alors, oui.
Mr. Green, just a moment. So this motion is now being circulated. I think it's relatively short. We can discuss it. I have Mr. Green and Mr. White who would like to speak to this, as well as Mr. Brock. Mr. Green, Mr. White, Mr. Brock.
It's around the table about presuppositions, and yet here we are presupposing we're going to have this thing wrapped up in the winter, I think is foolhardy and does not reflect where we're at all in terms of our witness lists, our work plan, and is premature in so many ways. I'm referencing from my community and from the public the lack of communications on the public inquiry side. I'll say that on the record, that people are frustrating. They're not hearing anything out of that committee. And I would just put to this one that if that committee is going to be a committee, or that process is going to be a process that goes away in private and kind of takes its time to deliberate in ways that are not open and transparent, it is incumbent on us as a joint parliamentary committee, with the seriousness of what's before us here, to provide answers to Canadians in an open, transparent, and public way. So, without not to get personal, I have a great deal of affection for Mr. Naqvi. I just think that this is very premature, and I certainly will not be presupposing that this will be wrapped up, given that we don't even know when we're going to get the documents. We don't know what witnesses are going to come from the documents. We have no idea what's going to happen over these next couple of months. And so, with all due respect to Mr. Naqvi, there's no chance that I would support this motion.
Merci.
Thank you. Mr. White, and then Mr. Brock.
Et ensuite, M. Brock.
Thank you very much, Mr. Chair. The expectation is we'll get documents by July 1st, which means that we will not have a meeting from that point in time until an interim report is complete, and I don't agree with that. My perspective would be that I would suggest that we adjourn debate on this and push it forward until a future date, because I don't think we will be prepared for an interim report.
Juste une seconde.
One moment.
Alors, il y a une motion de
Mr. White is moving a motion for adjournment on Mr. Naqvi's motion. This is a motion that is not debatable. I will call for the vote on this motion to adjourn Mr. Naqvi's motion. Madam Burke, sir.
Vote on the adjournment of the debate on this motion. The Honourable Senator Boniface.
Agree.
L'Honorable Sénatrice Boniface vote oui. L'Honorable Sénateur Carignan.
Carignan.
Oui. Oui?
Yes, yes.
The Honourable Senator Carignan vote oui. The Honourable Senator Harder, PC.
Oui.
Yeah, L'Honorable Senator Harder vote oui. The Honourable Senator White.
Oui.
L'Honorable Senator White vote oui.
Of Senator White to adjourn debate on the motion of Mr. Naqvi. Mr. Fortin.
Oui.
Mr. Green.
No.
Madame Bendayan.
Oui.
Mr. Naqvi.
Yes.
Mr. Virani.
Yes.
Mr. Brock.
Yes.
Mr. Motz.
Yes.
Pour 10, nays contre 1.
Alors, la motion, M. Naqvi.
It is adjourned then.
Comment along with Mr. Green's, just even about the theme of having a report done by this time. I think, quite honestly, and no offense, I have great respect for Mr. Naqvi and my friends across the way, but this is just an illustration to Canadians that there is a push to get this through this committee without having a fulsome, transparent, and accountable responsibility this committee has. And actually, I think that I'm glad this meeting is in public, because to me I'm actually shocked that these are timelines that the members of government think that this is a responsible, transparent, and accountable timeline to get through this. Obviously, whoever made that decision above the members in this committee to push that has no idea the witness list and hasn't seen the witness list, because it is extensive and we intend to go through it.
Merci, M. Motz.
Thank you, Mr. Motz. Mr. Harder, and then Madame Bendayan.
This seems to be the time for us to all give our personal perspectives. Let me say that I think it's important for the committee to get down to its work. I would also point out that the inquiry must report within a year of the revocation of the emergencies, and it would be ridiculous for this committee not to report before the inquirer. That would be my personal view, and I would encourage us to have a work plan that allows this committee to complete its work before February of next year.
Mr. Chair, my hand is up.
Oui, je pense que ça arrive qu'on ait des conversations qui ne sont pas vraiment.
Sometimes we end up having conversations that are not part of the public debate in this context. But that said, I understand Mr. Harder, Senator Harder, is suggesting that we have a motion to the effect that our work be completed before. Just a comment. Okay, thank you.
Après, monsieur.
After Mr. Harder, Madame Bendayan.
Just to respond to the comment by Mr. Motz, I have proposed on numerous occasions that this committee meet multiple times a week if necessary in order to get through our work. There is every intention to get through the witness list, and I certainly intend to ensure that that is done. And there was no thought given to circumventing the full hearing that needs to happen at this committee. But like Senator Harder, I do believe that we have an obligation to Canadians to report back on the work of this committee and to do so regularly, and to provide a final report before the public inquiry provides its final report, as I think consistent with the intent of the legislation, which was, as you recall, originally to oversee the implementation of any invocation of the Emergency Act, which was meant to happen before the public inquiry had filed its findings. So I think I speak for many of us, and certainly my colleagues, when I say that we intend to get through the work of this committee, but the work of this committee must include reporting back in a timely fashion to Canadians. And I think, once again, if necessary, this committee and each of its members should be prepared to sit longer and more often in order to get that done.
Merci, Madame Bendayan.
Thank you, Madam Bendayan. I have Mr. Virani and Minister Naqvi on my list. Mr. Naqvi, did you want to speak again? Or did you forget to lower the...
Alors, Monsieur Virani, Monsieur Naqvi.
Mr. Virani, Mr. Naqvi, and Mr. Green.
Virani, la parole.
Mr. Virani.
Echo the sentiments that were expressed by Senator Harder with respect to the need to get down to doing some more concrete work, doing it expeditiously, and reiterate that it would be extremely prudent to Canadians, to the people that we represent, to wrap up that work prior to the inquiry concluding its work, because I think that is what Canadians expect of us. And I would reiterate exactly what Ms. Bendayan just expressed in terms of repeated efforts on the part of her and others on our side of the House to make sure that we are doing just that. And I would reiterate, going back all the way to the reason for the cancellation of the previous meeting and a comment made by Mr. Brock, that something that happened at the Justice Committee was as a result of efforts by Liberals to prevent an adjournment of a meeting. That meeting was dealing with a bill called C5, which is a bill that many are familiar with in this committee room, many Canadians should be familiar with. And we would not adjourn proceedings at that committee to just prolong committee deliberations on a bill that needs to be addressed in terms of what it represents, in terms of curing mandatory minimum penalties that disproportionately affect Black and Indigenous men predominantly in this country. That is why that committee meeting dragged on, preventing this committee meeting from happening last week and preventing this work from occurring. Thank you.
Merci. Je vous ai laissé compléter.
Thank you. I gave you time to complete what your thought was there, Mr. Virani, but I must say that as chair, I don't think this is the right place to discuss what happened in another committee last week. So I understand that both opinions, both sides have been expressed, Mr. Brock and Mr. Virani. And now I would urge us to no longer get back to this issue. In other words, what happened or did not happen at the Justice Committee last week. That said, I have Mr. Naqvi on my list, Mr. Green, and Mr. Brock. Mr. Naqvi, you have the floor.
Thank you very much, Mr. Chair. And I really want to state this on the record. I've been fairly patient throughout the proceedings of this committee over the months, and I'm getting growingly frustrated. And I think that was reflected in the motion that I presented. You know, it feels to me that this committee is more interested in having procedural conversations ad nauseum at times, as opposed to getting to the work of this committee. And I think today is an example. We've had another 3-hour or so meeting doing exactly that. And I have found that when we've actually had witnesses, when we had the opportunity to hear from them, when we had the opportunity to ask them questions, we learned more and we shed more light on the invocation and the revocation of the Emergencies Act, exactly what Canadians want from us, than when we do what we just went through today. So I find it a bit odd when people are suggesting that somehow by putting forward a motion like that, I or others are trying to bring an end to this committee. It is absolutely to the contrary. What I'm attempting to do is place some focus to focus us so that we can get the work done. I agree with Senator Harder that it would be quite absurd if the work of this committee goes beyond that one of the public inquiry, which has a very set timeline. I think it's incumbent upon us to just roll up our sleeves and bring up witnesses, ask them the questions so that we can have a better understanding and we can report back to Canadians. My last point, Speaker, Chair, would be that sometimes it feels like that some members of this committee are almost looking for a make work project, that they would like this to go on and on and on until maybe up to the next election. And if that's what they're interested in, I don't think Canadians are interested in that. The Canadians want us to ask important questions of relevant witnesses and report back. And that's why I'm part of this committee, and that's what I intend to do. Thank you.
Merci, Monsieur.
Thank you, Mr. Naqvi. Mr. Green.
Thank you. And you know, like, I appreciated Mr. Varani's points. And I know, respectfully through you, Mr. Chair, the notion of referencing other committees. But I think in referencing the other committee dysfunction or filibuster or what have you, it recognizes the reality of the constraints of actual committee scheduling. So I don't want to mislead the public or have the public be misled that we're not doing the work because we simply don't want to work more frequently. The reality is there's administrative constraints here. And so, like, I look, coming out of this meeting, people are able to have their own comments, but they can't have their own facts. And the facts remain that we don't have the ability at carte blanche to sequester all the translators and the clerks and bring in Zoom to do this multiple times a week. That's just not the case. So the process is what it is because we have administrative constraints, not because anybody's looking to frustrate the process or to elongate this for quite some time. And, you know, to the other point about what Canadians want. Yeah, I keep hearing that. I want to reference again the imbalance that we have when it comes to access to information. The most basic information, Mr. Chair.
Excusez, Monsieur Green, je vous interromps.
Pardon me, Mr. Green. It's just that many people are speaking at the same time here.
On est plusieurs.
A number of people seem to be speaking at the same time, having parallel discussions. It makes it difficult for the interpreters, among others, and also for those who are speaking. So even though I don't like doing this, I'd like to urge you to be a bit more discreet. I think it's great to have free, open discussions outside of the official forum because it means that sometimes we can get to compromises, and that's great. But at this point, I think we're kind of losing control. I think, yeah, of course, it is late. It is 8:30. But that we still have an hour. And I would urge everyone to be more disciplined on these parallel side discussions so that everyone could do their job, including the interpreters. Mr. Brock, you still have the floor.
Has the floor. But
Green,
I will exercise.
Mr. Green, sorry.
Concede my time for the benefit of the committee.
Alors, Monsieur Brock.
Mr. Brock now.
Draw my intervention. Thank you, Chair.
Merci, Monsieur Brock.
Thank you, Mr. Brock.
Intervenez.
Madam Bendayan, do you have something to say? Yes, quickly, Mr. Chair. In response to what my colleague just said, if we can agree, we could ask the clerk for availability for the next 2 weeks, whether we could meet twice a week for the next week, the following week, and the one right after that. We have 3 weeks ahead of us. I think everyone agrees that it would be great if we could move ahead more quickly if we met more often.
Greffière,
Madam Clerk, is there some availability there?
vous pourriez nous... Et donc, Madame,
Madam Clerk, we'll look into the matter and get back to us with the proposal next week. Once she's taken a look at availability of rooms and staff. Mr. Brock.
I've spoken to the leadership of the Conservative team, and there is absolutely no chance at all. I applaud Ms. Bandayan's efforts to move this along because it is important that Canadians see that we are actually conducting business, not just talking about committee affairs, that we're interviewing and questioning witnesses. But the reality is meetings are being canceled, and they have been canceled literally for the last several weeks because of a resource issue. It's a limitation issue. And, you know, we can take a look at the larger picture and take a look at the hybrid parliament, which we've been subjected to for the better part of 2 years. That has contributed to a stretch on resources. The decision by the Liberal government to engage in midnight sittings on a fairly regular basis has really taxed our ability to find additional resources, particularly the extra work the interpretation team is doing, and they do it very, very well. But there's a limit to what we have. So while I applaud Ms. Bandayan's efforts to move this along, the sad reality is the government has contributed to the problem that we are facing.
merci, Monsieur.
Thank you, Mr. Brock. Any other comments? Madam Bandayan.
To respond to Mr. Brock, I certainly appreciate the information he's providing on behalf of the Conservative leadership, but with due respect, Ms. Candice Bergen doesn't speak on behalf of this committee, and I have asked the clerk of the committee to get back to us with respect to the availability of interpreters and rooms so that we may do our work expeditiously.
Il n'y a pas de problème, c'est déjà...
No problem. That's already agreed to. Madam Clerk said she would look into availability issues and report back next week at our next meeting. We'll see then. And there you have it. I understand Mr. Brock is expressing his opinion to the effect that there will be no availability. I would tend to believe that, but I guess it's still worth a try. We'll see with the clerk next week. And then we'll have to look at our agenda because now we've decided on a number of witnesses. There are others we'd like to hear from. Do we sit over the summer or not? There are a number of questions that we can look into. But at this point, next week, by next week, we'll have an answer from the clerk as to availability of rooms, etc. Mr. Motz.
Thank you, Chair, and thank you for Ms. Bandayan's intervention. We certainly are, we look forward to hearing from the clerk on availability and are certainly, open to additional meetings, however they may look, or at least having that conversation.
Merci, Monsieur.
Thank you, Mr. Motz. Any further comments? Madam Boniface. Senator Boniface.
I had a motion that I provided to the clerk to do with the oath of secrecy, and I wonder if it can be shared with everyone if it has not been done so. And I'm wondering, Mr. Chair, if while that's being done, if we may just take a 5-minute break.
OK, alors, la rencontre est suspendue.
We're suspending for 5 minutes, and when we get back, it is Senator Boniface's motion that will be on the floor. Thank you.
Good call.
Je vous invite à reprendre vos places.
We will resume. So we have Senator Boniface's motion now on the floor. Did you want to speak to the motion?
Very briefly, if I may, Mr. Chair, I think I've spoke to each of the groups around the table, and the purpose is really to give us a baseline on and a common understanding of the interpretation of the oath of secrecy. And so I would move that we go to a vote.
La motion est débattable.
The motion is debatable. It is subject to debate, Senator Boniface. So let's hear from those who would like to speak. I'll take names. Mr. Green.
I wish I had that power to just move the motion and get right to the vote. And I just shared these comments in person. I'd like to just reflect on them now that, I'm quite clear that when the law clerks come back, they'll likely have an opinion that the oath of secrecy pertains simply to the secret orders in council, in which I don't know whether we have or we haven't even gotten to that point yet. But I just want to be clear that in supporting this, that will be my understanding in terms of our oath of secrecy. However, I'm not willing to concede the fact that we still have the ability as a committee to get to the heart of the matter and have parliamentary privileges that are beyond what has been presented to us. And I just want to reference, Mr. Chair, when we hear members around this table talk about frustration and getting to work, I can't imagine a scenario where we continue to invite witnesses who continue to come before us and tell us they can't tell us anything. That's frustrating. And that was the case with the ministers that we had before us. That was the case with CSIS and with the RCMP. And so my hope is that in this motion, we also have the ability to contemplate when it comes back as a committee matters for which we are going to demand extra scrutiny, where we will hopefully create parameters of when we ought to be going into camera, to hopefully be privy to facts of the matter, because as it stands now, this motion will pass and they'll come back and just say it's a code of secrecy for the secret orders in council that were constituted over the course of the emergency, which will be likely very minimal, given what we already know as a committee. So those are my reflections on this motion. I'll support it, kind of knowing where it's going to go, but also continue to beat the drum about wanting to get to a place as a committee where we have access to real information and where we have a duty of candor from our witnesses. Right? And last point of contention is that, referencing back to the Attorney General, who's also the Minister of Justice, they're always both the client and the solicitor at all times. And therefore, my challenge is we're not going to have access to anything substantive. Thank you.
Merci, Monsieur Green.
Thank you, Mr. Green. I have my name on the list. Is there anyone else? Ms. Bendayan. So a quick word from me and then Ms. Bendayan. I'd like to draw to the Senator's attention, Senator Boniface, that there is an error in translation. In English, you state
Access from witnesses, mais en français, vous dites quel renseignement?
which information the committee can consult regarding the witnesses. That's not the same thing at all as the information that we obtain from witnesses. So that needs to be corrected if we are to work with this motion. That said, Senator, I gather that you're asking for a joint opinion that would force, in a way, both law clerks to reconcile their opinions with respect to an issue, but perhaps it might be worthwhile for the committee to get two opinions. If there are nuances, comments from the two law clerks, that they be in a position to do that. That they not be forced to simply work with this common joint opinion. So first of all, the issue of correcting the French translation, then the issue of the joint opinion, and then finally, I'm wondering if it's worth doing this right now, given the fact that we don't yet know what information we will obtain. Once the witnesses have produced documents, once we have information, then we can ask the law clerks if that information is covered or not by this oath of secrecy. I wonder if this is perhaps not a bit premature, so those are my three comments for the committee. Most urgent being this French translation of the document, because if we have to vote on this motion, it would be important to make sure that we're all looking at the same question. At this point, if I look at the French version, I would say it doesn't make sense. I can't see how law clerks can tell me what information I will consult regarding the witnesses. I'll go to Google and see who the witnesses are, but we're talking about two different things. Madam Bendayan.
Oui, merci, monsieur.
Yes, thank you, Mr. Chair. I have the same concern as you to some degree, Mr. Fortin. Of course, no one can speak on behalf of the law clerk in question, but by inserting this date of June 13th, there is a hope that it would be received by then, but the law clerk will be able to tell if it's possible or not. I certainly hope it would be the case. I would note, in this same vein as you, Mr. Chair, that in French it says it has to be sent to the members before June 13th, and then we see by June 13th in the English version, so that's a detail. And finally, Mr. Chair, I would ask the senator to clarify this. It doesn't have to be in the motion as such, that this is something in writing that she'd like to have, given the fact that we've just adopted the motion on future meetings for the committee. Perhaps we would agree to something in writing, but I don't quite see if there's a time for the law clerk to come and discuss the findings at this point. Thank you.
Est-ce que quelqu'un d'autre?
Anyone else? Senator Boniface.
Thank you, and thank you for pointing out the French. It did go through translation services, so I regret that it's not accurate, but I just want to reassure you it was sent to translation services, so I can have that adjusted. The intention here was it would be a written opinion, not an appearance and such, and just for the basic information of the committee members around the table, and we thought that that would help us as we move forward. So I didn't see it as premature, to your point, Mr. Chair. I saw it as merely giving us a piece of information to help us as that new information comes forward on redactions and such like, and in our planning going ahead for the work plan. I'm in your hands in terms of how you'd like to do it. If you want me to bring it back to the table, I could do that, and with the correction that you suggest, I'm in your hands either way.
Merci. Monsieur.
Thank you, Mr. Green.
While I appreciate, in reading this, while I appreciate having the opinions, the joint opinions of the law clerk of the Senate in the House of Commons, I think that this is actually contrary to our standing orders and our parliamentary privilege. And what my question through you, if I could, Mr. Chair, to Ms. Boniface is that as a chair, would you use this opinion to guide what questions were in or without the mandate of our questioning and our lines of questioning?
I think that your question actually demonstrates what I see as an issue around the table. So I was trying to get clarity. Is the perception to what information an oath of secrecy gives us? What does the oath of secrecy make this committee's operation different than others? So as an individual, both in what I have access to, but also in terms of what I can share. So the whole point of this was merely to say we took an oath of secrecy. I'd like to know what exactly that allows us access to, because that's not a normal practice of the committee. And it's not something we asked the clerks when they were here. But I thought this would be a rather quick motion. It was really to try to get that single clarity, because when I have discussions with individuals or in our groups, I feel that there's a very different understanding around the table on what the oath of secrecy's impact is for the work that we're doing. And I just wanted, as I described to some of my colleagues at the table, kind of what's the baseline? And that's what the law clerk's legal or opinion would be in writing. And so I leave it to the committee. It's a suggestion and a motion I put forward.
J'avais ajouté mon nom.
I added my name to the list while you were speaking, Senator Boniface. The comments I made, based on what I said as a member of the committee, would it not be wise to simplify things, to invite the two law clerks to a future meeting so that we can all ask questions that may be of concern to us on that particular point regarding the oath of secrecy, the scope of that, perhaps it would be clearer to ask them. It might be wise to hear from them both, to have them both before us. Tell them ahead of time we want to discuss the breadth of it, of this matter regarding the oath of secrecy, and then we can ask them the questions directly. I had Mr. Varani and Mr. Harder.
I'm just conscious of the need to get on with the business of the committee hearing witnesses. So I think the motion as created and as articulated by Senator Boniface is useful. I would just perhaps insert the word seek a joint written opinion from the law clerk to make it crystal clear. And then perhaps if there's any necessity after the fact, after we receive the written opinion, we could pose some interrogatories to the law clerks at a later date.
Monsieur Harder.
I just agree with what Mr. Varani has said and was going to say the same thing. So I think with that understanding, I'd be happy to vote on this.
Voter sur.
To vote on what Mr. Varani just put forward?
Voter sur la motion de Madame.
Vote on Madame Boniface's motion?
It is written. I would suggest we move to a vote. Here.
OK. Donc, moi, je veux bien qu'on vote, là, Monsieur.
I'm willing to vote, Mr. Harder, but we'll have to agree on this issue of translation before we vote. Otherwise, it's out of order. I'll have to say that because... So I'd suggest we suspend for 2 minutes. So we'll resume. Senator Boniface, we worked on a homemade translation, shall we say, of your motion. I'll read the French version. The interpreters will read it. I'll read it slowly to make sure we're all in agreement. The interpreter will read the English text. I move that the committee seek a joint opinion from the law clerk of the Senate and the law clerk of the House of Commons as to what information the committee can access from witnesses in relation to or given the oath of secrecy found in the schedule of the Emergencies Act and referred to in 62.3 of that same act, and that the joint opinion be submitted to the joint committee clerks for distribution to members by, or at the latest, by June 13th, 2022. Does that suit everyone? Any proposed amendments? Yes. Oh, actually, we'll get to that. But on the original motion, that's what I've just read. Is that fun? Is everyone in agreement with that? Everyone agrees to that translation. So we had Mr. Virani who had a motion or that this joint opinion be in writing. We would then have to vote on that amendment before we before we go to the main motion. I hadn't proposed, but I will, or I might, that we get two different opinions rather than a joint one. Let's go to Mr. Virani's proposed amendment. In other words, that it be in writing, this joint opinion be in writing. Anyone on that? Mr. Carignan. Actually, I'd like to get to the issue of the written opinion, also of just the opinion in general, whether it's written or not. I feel that the clerks are being put in this very sensitive position, difficult position. It's theoretical, abstract. What information the committee can access from witnesses, it's really broad. We don't have any facts or types of information, no specific situation to refer to put on the table here to refer to this opinion. How will she do that? With respect to this type of joint opinion, there would have to generally be a factual basis, and you'd have to identify specific information. I'm concerned this may be theoretical insofar, or so long as we don't have something specific, a document or something that we're asking for an opinion on. So I think someone else has said this, that I'm of the view that it is premature. So long as we do not have these documents before us and that we can ask for something specific about them.
Merci. Est-ce que quelqu'un...
Thank you. Anyone else? On the proposed amendment, Mr. Virani's proposed amendment.
Okay, alors...
Are we unanimous on this, or do we want to vote on the proposed amendment to the effect that it be a written opinion? In other words, in French, I'm reading, I move that the committee seek a joint written opinion. Is everyone in agreement with that? Okay. Now, I'd like to come back with another proposed amendment, if you'll allow me, Mr. Chair. Yes, Mr. Fortin, go ahead. Rather than a joint opinion, I would suggest that we call for or seek opinions from both the law clerk of the Senate and the law clerk of the House of Commons. Mr. Green.
I understand the intention and the direction, but I also don't know if it's fair of this committee to ask the two houses to potentially be at odds in this particular scenario. I think we're asking a lot of them as it is for the same reasons why Senator Carignan has raised and for the issues that I've brought up. So, yeah, I'm just cautious around that. And I think that if we have them work together to get to whatever their legal opinion is, I'm of the mind, and I'm going to presuppose that they're going to come back and talk about the specificity of the special orders under the Act that were secret, that I'm to understand didn't exist. So I'm not sure there's going to be much that actually comes of this, but I also don't want to put them into a scenario where they go in completely separate directions and then we're left holding the bag on that.
Merci, M. Green.
Thank you, Mr. Green.
Il y a M. Harders, mais je veux juste préciser qu'on m'a...
I was advised that senators have to leave us. Am I correct? 9:20, Senator Boniface?
Ah, 9h40. Ah, mon Dieu.
9:40. Okay, Mr. Harder.
Thank you, Chair. I would be against your motion for the reasons that Mr. Green has cited, but I would also make the point that it would not surprise me if the opinion had a range of understandings that might be nuanced and not necessarily narrow and prescribed, but it could incorporate differing perspectives, but it would be useful to have in one document without going through the parsing out of one chamber's view versus another chamber's view.
Est-ce que
Anyone else? Mr. Harani.
I just think if we asked 5 different lawyers, that we'd possibly get 5 different opinions. So the notion of asking for more than one is probably a dangerous proposition. So I agree with Mr. Green, which might be the first time this evening.
Alors, je suis d'accord.
I agree with you, Mr. Varani. We would get 5 different opinions from 5 lawyers, 2 from 2, but I think it actually would be beneficial. But anyhow, I understand that committee members are not interested in hearing from having both, so I'll withdraw. Now, on the amended motion, that it be a written opinion and then as amended for these corrections in French. Anyone else? Senator Carignan had something to say about how sort of premature the motion might be. Anything further as to the motion as a whole, or should we move to the vote?
Alors, Monsieur...
Madam Burke?
Ah, est-ce qu'il y a unanimité?
Is it unanimous? Are we unanimous? No?
Par appel.
A recorded division, please.
On the motion as amended, the Honourable Senator Boniface. L'Honorable Sénatrice Boniface vote oui. L'Honorable Senator Carignan CP.
No.
The Honourable Senator Carignan PC votes no. The Honourable Senator Harder PC.
Yes.
L'Honorable Senator Harder votes oui. The Honourable Senator White. L'Honorable Senator White votes oui.
Non.
Mr. Green?
Oui.
Ms. Bendayan?
Oui.
Mr. Nakvi?
Yes.
Mr. Varani?
Yes.
Mr. Brock?
Oui.
Mr.
It's supposed to be mine.
Was it?
Mr. Motts?
Yes.
Next thing you know, he's a breaking ball. Monsieur Brock. Welcome to the court.
9-2, yeah.
Pour 9, nays contre 2.
Alors, la motion est adoptée.
It is adopted. We have 10 minutes left. I was asked to close at 9:30 as expected. I understand that the senators have to leave at 20 to 10, but in my view, I think we've exhausted our agenda for today. Am I correct? All right, then we can adjourn.